Hi, everyone. I know we are right at noon, but the attendees keep rolling in, and we were expecting about 200 folks for this webinar. So I'm going to give everybody a chance to roll in. We will get started in 2 minutes, and I promise we will get you out of here on time as well. Okay, I see the attendee list slowing down. So we'll let people continue to roll in, but we will get started because we've got a lot of material to cover today, and I want to make sure to get us in and out and get it all covered. A couple of background items for what is happening today and for housekeeping items. Welcome to Civil Justice. Well, we changed it. Welcome to Victims of Crime and the Civil Justice System in New Jersey. As an FYI, this is almost all going to be New Jersey law based. So if you are from another state, some of this will apply to you, but some of it won't. And this is not meant to be legal advice. So please get in touch with us and ask any questions if you have any questions that aren't based on New Jersey law. We may not be able to answer them today, but we will definitely try to get you an answer later. A couple of things of how NCVC runs webinars. Go ahead and keep chatting in the chat, say hello to each other, socialize. We do leave that open so that everybody can get to know each other, but we do only take questions from the Q&A section. So I know it's 2025 and we've been on Zoom for the past 5 years, but in case you don't know how a Zoom webinar works, if you scroll to that bar, that black bar that has all of your options, you should have a chat option. And if you're not seeing something that says Q&A, go ahead and find the three dots that say more options or just more. Click that and there will be a Q&A that pops up. We will take all questions from that Q&A. Everybody is muted and will remain on mute. And go ahead and ask your questions when you have them. We like to take questions as they come. So if we say something that you've got a question about, don't hold it to the end. Go ahead and ask. If there are questions you have that are just general, feel free to ask them whenever or hold them to the end. That's up to you. We will not be giving any CEUs today. We do not have CEUs for this. However, we will be providing a certificate attendance if you need it. If you fill out, we have a survey at the end. Crystal will drop it in the chat. We will also be sending you all an email with today's materials, with the emails from the attorneys so that you can get in touch with them, and with a couple of other things. There will be a link to a survey in that. Once you complete that survey, we will be sending you a certificate of attendance. I think that's all I was supposed to cover. It's always a really long list. So welcome to Victims of Crime and the Civil Justice System. And we put civil in parentheses because we're going to mostly cover the civil justice system, but we'll have a quick review of the other justice systems and how they interact with crime victims' rights in a few minutes. I'd first like to say a special thanks to our hosts and have them introduce themselves. So starting with Guy DeAndrea. Guy.
Thank you, Renee, and thank you for having me. Yeah, my name's Guy DeAndrea. I was a assistant district attorney in Philadelphia for just about 9 years. I was in the child sexual abuse unit, and then ultimately the last 5 or so years, I was in the homicide unit. And when I was deciding to leave the DA's office, I still wanted to continue the fight for victim survivors. And the 9 years there, I didn't really know much about the civil process other than I obviously know about civil law, but as it relates to helping victim survivors. And so finding a place that allows me to exclusively represent survivors of physical and sexual violence, bullying, and hazing all across this country. My hometown is Philadelphia, so I'm in the Philadelphia, Pennsylvania, New Jersey area a lot, but I had cases all around the country. And my focus is on those institutional abuses that happen, especially in boarding schools, daycare centers, massage institutions. Name a religion, I probably have sued them. I'm not trying to be funny, but it's so pervasive, so sadly in our country. and the civil justice affords, which we'll talk about survivors, just a very different type of justice.
Thanks, Sky. And then we have two folks. I'm going to let Brian introduce himself. We have Brian Doyle. Go ahead, Brian.
Thank you, Renee. My name is Brian Doyle, and I'm an associate at Soloff and Zervanos. Before I joined this firm, I practiced employment law and civil rights law for nearly 10 years. During that time, I became acquainted with Soloff and Zervanos and Jeffrey Fritz, who will be joining us later. And at Soloff and Zervanos, we largely represent victims of crime and bringing civil actions to try to get them justice. And so I've been here about 3 years, and in that time, we've really cultivated an effective way to represent the victims of these kind of crimes. Yeah, thank you.
Oh, and Jeff Fritz. So everybody knows Brian is pinch hitting for Jeff, who is joining us from his car phone and would like to introduce himself. I was going to give him an introduction, but Jeff, go ahead.
Oh, hey, I'd rather hear your introduction. Probably be better. So that you all know, I'm doing this very safely and just have everything mounted here. Um,
Oh, Jeff, you're breaking up, so we're going to let you get into the office, and then we'll give you a chance to do your intro.
Yeah.
We'll give you, I'll intro you and
Okay.
we'll give you a chance. Apologies, everyone. Jeff is being a real team player and trying to join us. Jeff is a partner at Soloff and Zervanos, and he is a longtime member of the National Crime Victim Bar Association, which we'll talk about next. And much like Guy, he has probably sued every religion and some major school systems when they have really failed in accountability and failed in liability to protect children and to protect victims. So we are very grateful for them joining us. They will have lots of good stories for you all and lots of good tips and advice for how to help victims through the justice systems. A little bit quickly about my organization, the National Center for Victims of Crime. I believe you all probably know quite a bit about us already because you signed up through our listserv. We focus on advocacy for victims, public policy, public education, and this presentation is being done through the National Crime Victim Bar Association, which is a professional association of attorneys that are dedicated to helping victims seek justice through the civil systems. Some of the things we do through NCVBA are we provide seminars like this. We also provide full day seminars, and we host an attorney referral service, which you all can access at victimbar.org. We try to connect individuals who have been victims of crime to attorneys that can truly help them. So again, if you'd like more information about a civil justice seminar in your state, go ahead and email me. It's rwilliams@victimsofcrime.org. In the alternate, there's a whole lot of information available at victimbar.org. We also, as you all know, because you've been receiving up-teen updates about it, we have a national training presentation that I'd like to encourage you all to attend this year. It will be in Orlando from September 3rd through the 5th. We've got lots of fun surprises planned because not only is it our 40th anniversary, but also we are in Disney. So we hope to see you there. So a little bit about our audience, because we always like to start with this so we know who we're presenting to and kind of what the level of expertise is. So if you could just pop some answers to some of these questions in the chat, we'd appreciate it. How do you serve victims of crime? What state are you primarily in? And what is your experience within the civil justice system, if you have any, or if it's just some confusing mass to you, which I think it is to many of us. So I will scroll up. So we've got quite a few New Jersey folks. Women Rising Husband, Emergency Protective Orders. Oh, Texas. Welcome, Texas. How many attorneys do we have if you want to call yourself out? You don't have to if you don't want to. Disability advocate, victim advocate, want to go to Florida. Awesome. We hope you're in Florida. Okay, awesome. We've got a couple of new civil attorneys. Amazing. Victim advocates. Awesome. Thank you guys for participating. That helps us quite a bit in understanding who we're talking to and what we want to be saying. So I want to address a few misconceptions about the justice system as a whole and a victim's place in it at the outset, because these are important as we get into this discussion to keep these kind of in the back of your mind. First of all, we have this misconception, I think it's brought to us by years of TV, that everybody has a right to a lawyer. That's not true. Um, Everybody has a right to an attorney if you can afford to pay them, unfortunately. So only in criminal cases in the US does the government absolutely have to provide the defendant, and the defendant only, not the victim, with an attorney. That means that you can always have an attorney present, but again, you have to be able to pay for them. In some family law cases, such as child removal, a state will provide an attorney for the parent and a guardian ad litem for the child. Again, that's only in child removal cases. In some cases, you can get a lawyer through Legal Services Corporation. Those are usually in domestic violence cases. And if you have any experience with legal services, which I came from legal services, those attorneys work very, very, very hard, but they are very, very, very overstretched and very, very, very underpaid. So victims don't always have a right to an attorney. A lot of folks, especially when they are victims, say that they would like to plead the fifth. There's only a right against self-incrimination if the information is going to be criminally incriminating against you. So only if you're about to face criminal actions can you say, I plead the fifth. That does not apply in general victims cases just because you don't want some information out there. It has to be criminally implicating. This one we're going to talk about, which is one of my favorites. Winning a lawsuit means you'll get a ton of money. We hear people yell all the time, I'm going to sue you. Well, that's nice. It doesn't really mean much unless there's money to be had. Going to court doesn't cost individuals anything. That is completely incorrect, and we're going to talk a lot about that. And then this is one I'd like to hear from you all on. When you are a victim of a crime, who do you think pays for your expenses, your medical expenses, your property expenses, your attorney's fees? Who pays for those things? And put it in the chat if you think you know or if you have an answer. BCCO, the victim does. Aaron Johnson gets the prize. I'm sorry, Aaron, there's not really a great prize. The victim does. The victim is responsible for all costs. Now, insurance can kick in. Isabel's right. If they have insurance, that's great. That does kick in. But for the most part, it's really expensive to be a crime victim, and there's nobody to cover those costs, even for attorneys. Yes, sometimes VCCO, so victims' compensation, can assist. We're going to talk a little bit about some of the barriers around that. So, an overview of the justice systems that we're talking about today. We've got the criminal justice system, the civil justice system, and those are the two that we're going to talk about. But I always want to make sure I call out family court. Family court does technically fall under the civil justice system. However, it's a very different process, and it does directly implicate crime victims. But this is one of those cases that we talked about that, one, you don't get a free attorney, and two, the courts don't necessarily make allowances just because you're a victim of domestic violence or sexual assault. So the family court system covers divorce, custody, and alimony. Unfortunately, almost all of that in the US falls under contract law. So a divorce, most states, not all, are considered no fault. So they don't necessarily care when they're dividing up property and when they're making monetary decisions, whether there was abuse, whether there was infidelity. The marriage is just done. And if there was a prenup, that prenup rules. If not, everything falls under contract law. And custody is determined solely by state law, unless there's abuse there. And abuse allegations can play a role, but they have to be proven. And unfortunately, most judges are very leery about that. I'm going to go out on a limb and say Brian and Guy, and also myself, are not experts in family law in any way, shape, or form. I don't know Brian as well, so maybe he would like to pipe in and say he is, but we are not. So we're not going to talk about family law now at all. It's just super important that you all kind of have that background and understand that we can't really answer those questions. You do need a family law attorney. This is everything I just said, so we're going to skip this slide for the sake of time. So getting to the criminal justice system, and this we're going to contrast this with the civil law justice system. I know most of you probably know this, but there are a couple of things we need to call out just so when we're having the conversation about the civil justice system later, you all understand it. So, Guy, you are a prosecutor. Do you want to walk folks through the criminal justice system?
Sure. I mean, seeing the responses, I know some of this will be well known, if not old hat, to so many of the individuals on here. But the significant difference, and some of this might sound obvious, but when you're talking about the criminal justice system, at least from my perspective, and I think the laws play this out as well, almost all of the, I'll call it benefits, whatever word that's what I used to use as a prosecutor, all go to the defendant, right? Now, obviously there's constitutional protections, and we need to afford anyone alleged to have committed a crime all of the constitutional provisions and protections that are in place for that individual. However, what in that conversation, what rarely is discussed is the victim survivor, right? Before I went to homicide, and even when I was in homicide and we were scheduling things, for instance, I remember very candidly, the judge would say, all right, defense attorney, this is what we're looking at for the jury trial. What's your availability? Mr. or Mrs. Prosecutor, what's your availability? What's the police's schedule? What's the defendant's family schedule? Rarely would they ask, what is the victim's survivor's schedule? What does it look like? What is the family of a murder victim? In a lot of my cases, what's their availability? It's so often an afterthought. So that's a significant way that the criminal justice system, I think, in many ways is different, which you'll hear about, than the civil justice system. We all know the remedies that are available. Almost none to the victim survivor, right? So, it's a punitive system in all ways, right? I mean, yes, there's rehabilitation and things along those lines, but it is removing someone potentially from society who is a harm to society. And so while that protects a whole host of people, and it may very well, especially in domestic violence circumstances, protect the victim survivor, oftentimes the focus is protecting society as a whole. And what gets lost in that often, not always, but often, is the individual person who is affected, usually very horrifically, by the offender, if in fact the offender committed the offense and has been found guilty, right? So, in terms of what is the justice that's happening, you're protecting society. And sometimes as a byproduct, of course, you're protecting the individual survivor, but more often the focus seems to be on the defendant and society as a whole, which you'll hear about in a few moments. It's the complete opposite in the civil world. Many times the victim survivor has little to no control over what happens, right? A prosecutor, certainly, if they're a good one, can seek the input of the victim survivor. But ultimately, in many jurisdictions, if the prosecutor chooses to make an offer that the victim survivor is unhappy with, it's kind of like too bad. Now, if you're a good prosecutor, you wouldn't do that unless, of course, justice requires that, and that's a difficult conversation. But overall, victims are given the ability to tell their story, although it is, of course, limited during trial to the rules of evidence, right? It's not like a deposition, which you'll hear about in civil, where they can tell their full truth, right? In criminal, they're subject to the rules as it relates to direct, and then cross, as we all know, is brutal on victim survivors. But it is still an incredibly important aspect of justice, because of the holistic, idea of protecting society, and again, in some ways, protecting the individual. But the real focus, as it relates from my view, for justice for the individual, really comes in the civil side of things.
And I just want to point out two things from this slide too, because we're going to bring them in later. And I did see Aaron call this out in the chat. In the criminal justice system, the state must prove guilt beyond a reasonable doubt. Brian or Guy, I don't know who is closer to graduating law school. Who remembers how our law school professors described what beyond a reasonable doubt means? How heavy is that burden? Oh my God, they're both
I'll jump
confused.
in. So
Okay.
I mean, yeah. So the most of my professors, especially, I'm not trying to get political by any stretch, but if you are more left leaning, I mean, my professors were, it's not beyond a reasonable doubt, it's beyond all doubt, right? I mean, and when you get to homicide or, horrific acts of sexual violence that, the jurors, while they're not allowed to know, they know the consequences and gravity if they find the defendant guilty. It's life potentially in prison, if not, worse if your state has the death penalty, right? Which, but anyway, so meaning when they're the more grave the offense, rape, for, felony of the first degree rape, homicide, especially if it has an act of sexual violence component in it, jurors, and I've interviewed many of them, I mean, I've too many to count. The idea of I could have some doubt that no, it is beyond all doubt is what's in their head, despite the jury instruction to the contrary.
And I think the other important thing for everyone to keep in mind for later discussion again is that you walk in and the jury is told that you have to presume that the perpetrator is innocent. And we're going to talk about why that's slightly different in the civil justice system.
Oh, let me just chime in on that point real quick, Renee, 15
Absolutely.
seconds. In a criminal trial, the defendant obviously never has to testify. You cannot compel the defendant to testify. Not true in civil, which you'll hear about. And even if the defendant testifies and there's some version or certain questions, the defendant's going to plead the fifth to, the jury does not get to hear that, right? They do not get to hear the defendant invoking his or her, more often than not his, Fifth Amendment right against self-incrimination, which again, we'll hear about how that's the complete opposite in civil and the power that it gives the survivor and their attorney when a individual perpetrator pleads the fifth.
Mm-hmm. And so, as Guy mentioned, and as we mentioned before, victims' rights within the criminal justice system, we've made huge improvements. We've made a lot of improvements, but they're still hard to pin down. There are amazing prosecutors out there. This is not a rip on prosecutors in any way, shape, or form. But as Guy pointed out, they do not represent the victims. They represent the state. And that makes a world of difference. A prosecutor's job is to see that justice is fulfilled. It's not to protect the victim. Victims have a right to counsel present throughout the justice process. Again, that's if they can afford one. And that's not always necessarily going to make a change in the justice process. It's more to help guide them. And we have our partner website up there, nclvi.org. They provide amazing counsel, and they will also provide a referral to attorneys for victims that are going through the criminal justice process. And we always hope that victims are directed to victim advocates, whether through the district attorney's office, a law enforcement office, or local victim service providers. However, much like legal aid attorneys, those advocates have a giant caseload and are very underpaid, and we appreciate that. But so there's a lot that goes into protecting victims' rights within the criminal justice system. I also want to talk about, as we mentioned before, the criminal justice system is super, super expensive. It is expensive to be a victim. And one of the few things that is available is either restitution or compensation. Restitution is from an offender, and it has to be assigned at the time of sentencing. A lot of times restitution isn't very helpful to victims because it's money that you're getting from an individual who's been found guilty, who is likely about to be incarcerated. So sometimes that's like drawing blood from a stone. You also have compensation. In victims' compensation, New Jersey is one of honestly the better states I've seen. It's very touch and go, but there are absolute requirements. The victim has to cooperate with law enforcement, absolutely has to. And the claim for compensation must be filed within 5 years, and the crime has to have been reported within 9 months. So a lot of times what we know about sexual assault is it's not reported until later. So often compensation will not be available for sexual assault victims. And then Guy and Brian or anybody in the chat, is New Jersey compensation a payer of last resort? So do you have to pay back the comp board if...
Yes.
I knew Jeff would know. Jeff, can you explain that?
So, yeah, think of the Victim of Crime Compensation Office, and I'm sure most folks know this. They're there if there is no other insurance, if there is no other immediately available way to pay for such things as lost wages, medical expenses, relocation expenses, counseling, things like that. Now, sounds like, well, you know, what does that do to my civil case? They do have to be paid back. The state has to be paid back, but it allows the victim, the family members to get some of the expenses related to the crime paid immediately, and then yes, they get paid out of the civil case. So it serves a very good purpose, and I have always found that the VCCO is willing to work with us in terms of reducing the amount that has to be paid back. And there was a comment, you're paying back 2/3. That's typically the case. Sometimes it can even be negotiated for even better amount.
Thank you.
And
And Jeff,
I'm sorry for the lateness, by the way.
Jeff, would you like to give yourself an introduction, or were you good with mine?
I always go with yours, but just to let folks know, I'm in New Jersey. I practice in New Jersey, Pennsylvania. I've been doing this for about 30 years, and I've worked with Guy on many cases. I work with Brian on a ton of cases, and these are all good guys to work with. And I've just been of representation of victims by medical providers, schools, cults, kind of you name it. So thank you. And I, again, apologize. I was in court for a victim this morning and driving back.
We appreciate you making it. And perfect timing, because we are getting to my favorite part, which is the part where I don't have to talk as much anymore. We've laid the groundwork for everything. We've walked very quickly through the family law system and the criminal law system to get to what we're supposed to be talking about, which is the civil justice system. And the reason the civil justice system is here is that even if there's a successful prosecution, as we just discussed, the victims can feel left out, or there's a variety of issues that they're still left holding a bag. And so there's a lot of criticism of the civil justice system. There's a lot of criticism of some of the attorneys that try to help victims through the civil justice system. But it is a wonderful tool, and it is a wonderful mechanism for victims to find the justice that they deserve, that oftentimes the criminal justice system denies them. You'll see a lot of this in the Diddy case, and we'll probably discuss the Diddy case later. But why do people hire lawyers before they go to police? A lot of good reasons that have nothing to do with money. So let's get started with that. Jeff or Brian, you know what? Let's hear from Brian. Brian, do you want to give us a basic overview of the civil justice system? Who's who? How's it different?
Sure. Well, sure. I mean, I think the primary difference is, rather than the government and the prosecution being in control of what happens with the case, it is driven by the plaintiff and the plaintiff's attorney. The plaintiff in a civil justice, in the civil justice system, has a burden of proving their case, but rather than proving it by beyond a reasonable doubt, the burden there is to prove it by a preponderance of the evidence standard, which is much easier. The plaintiff can be, can be one of the victims. It can also be the victim's family member, if the victim is, under the age of 18. And there's no presumption of innocence in the civil justice system like there is in the criminal justice system. So there's no situation where the jury is informed that the assailant is presumptively innocent. This is because the civil justice system isn't looking for guilt or innocence. It's more focused on the harm that is being done to the plaintiff. Jeff or Guy, do you have anything you want to contribute to this?
Are we just talking about plaintiff right now?
Well, just an overview, and I think one of the more important things to chat about is we made sure to highlight the burden in the criminal justice system. How does that differentiate from the civil justice system?
Yeah, wildly different. And so it's a preponderance of the evidence. In other words, I hate to use the cheesy scales of justice, the analogy we all hear in law school, but it's 50.00000001%, and you win your case, right? And so a jury does not have to find beyond reasonable doubt or any doubt or anything along those lines. Essentially, it's more likely than not. Is it more likely than not that this occurred? And is it more likely than not the plaintiff is telling the truth? Like, more likely than not, it's not a huge burden. That's not to suggest the cases aren't difficult. They are incredibly challenging. Why? Why are civil cases challenging? If you're talking about a burden where it's you just need a little bit more than the other side to win, because in the civil justice system, which I know we'll talk about, the defendants, so I know we're up here, generally speaking, are institutional defendants, churches, daycare centers, boarding schools, massage institutions, right? Organizations, sports organizations, public schools, private schools that have allowed, usually, repeatedly and for years, abuses to occur under their nose, or quite frankly, with their own blessing. And so that individual, not that individual, that defendant, the institutional defendant, has all the normal defenses or arguments. Well, hang on, even if this abuse or assault occurred, it happened at the hands of this person. How are we at fault? And that's where we come in to prove they're at fault. Now, the reason it's so important from a victim survivor perspective to have an institutional defendant is because in civil justice, largely, almost exclusively, if you go to a jury trial, it certainly is exclusively, the remedy is very different. Remedy is a financial remedy. Now, if you negotiate a case, we could talk about that later, all the different things you can do. But if you go to a jury trial, there's one remedy, and there's only one remedy, and that is financial compensation for the victim survivor. And so if you have a defendant who's serving life imprisonment and doesn't have any money, and there's no institutional defendant, you have to be open and honest with the victim survivor. Otherwise, you're putting them through a civil case, civil justice, a trial potentially, where at the end of the day, you tell them, all right, you won, but you didn't actually win anything because the defendant is incapable of satisfying, paying the judgment, the remedy.
Yeah, and we're definitely going to get into that. But that is a very good point. Oh, Jeff, do you have something?
Real quick, I think the simplest way to look at this is, you touched on it, but let me finalize the point. That criminal case is the state's case. It's the state that makes the decisions, that decides what are we going to charge, what are we going to look into, and ultimately sometimes what's the plea deal going to be. The civil justice system affords victims something totally different, and that is it's the victim's case, and the victim gets to decide, how does this case get started? Where does it get started? Everything in it, in conjunction with their counsel. And ultimately, does the case resolve? Does it go to trial? I always say, and it's just true, every single victim that's ever come to me, the second thing or the last thing they're thinking about is the money. It's about, I want answers. I want to know what happened. I want to know how this came to be. And that's what the civil justice system gives them.
And so lots of benefits. Whenever a case is brought under the civil justice system, it's brought under what we call torts. And I know we've got some lawyers on, we've got some non-lawyers on. The first class that is an entirely long semester class in law school is torts. And we're going to boil that down to 15 minutes. But it's important that you understand that these are all of the cases, whether it's sexual assault, whether it's gunshot violence, any case that is for crime victims is going to be brought under this idea of torts law. So who would like to explain?
Renee, before you do that, I think there's a really important question in the Q&A.
Oh, I missed it.
Yeah.
Is it more so that does come up. Do you want to talk about it now instead, and we'll skip over it later?
I think so, because it's an overarching thing, and I mean, I'll give a 30-second pitch, and then obviously Jeff. So.
Wait, let me read it out loud in case anybody hasn't seen it, because not everybody can read the Q&A. Is it more beneficial to have a victim file a civil case versus a criminal case if there is a choice, or both? And while you're talking about that, do you want to talk about timing as well?
Yeah. And so that's exactly what I'm going to get at. So many times a victim survivor will come to me, Jeff, right, first, before they even called police, or sometimes it's contemporaneous, and it's like, do I have to go through the criminal justice system? Some want to, some don't. Now, there are a lot of civil attorneys who will file a civil case without waiting if criminal charges are pressed or filed, without waiting for those criminal charges to complete. Now, there's statute of limitations issues, there's reasons you might have to do that. But putting all that aside, if you do not have to file your civil case because of statute of limitations issues, the way that I counsel victim survivors, if this is what they want, meaning they want to do the criminal process, is have me there as a victim advocate during your criminal process. I don't care if it takes I know the victim survivor does, but it takes 2 years, it takes 2 years. The outcome of there can be immensely beneficial to them on their civil side because it removes a defense, meaning if the defendant is found guilty of the intentional acts committed upon that person, the institutional defendant doesn't get to defend the case on before we even talk about whether we're responsible. We don't even believe that this happened. Once you get the criminal conviction, they're stopped from making that argument. And so if the client wants to go through the criminal process, if I could have it this way, it's let the victim survivor walk through the criminal process, complete that, and then as soon as that's over, we'll go ahead and file their civil action. Jeff, I don't know if I
Yeah,
your
so
answer.
I fully practice the same way that you just said, Guy, but there's a couple other reasons too. So yes, once there's a conviction, that conviction can be used, whether it's a plea, whether it's a jury verdict in that criminal case, that can be used in the civil case. That's only part of it though. We have also have the benefit of gaining the information from that police investigation or that prosecutor's office investigation, but we can't get it until the criminal case is done. We also don't want to, so that's why we wait. We also don't want to feed into any defense. I was involved in representing a lot of the Sandusky victims, and the entire defense for those of you who remember Jerry Sandusky or don't remember Penn State, but the entire defense in that criminal case is this is just all about money. These victims are coming forward because they want their payday against Penn State. And of course, that wasn't the case. But we don't want to be sort of out front and bringing a civil case while that criminal case is pending because you're feeding into this defense. So we want to avoid that where possible. And then there's just another simple practical reason. Most judges, most states will stay or freeze your civil case while that criminal case is pending. So there's no benefit to bringing that civil case while the criminal case is pending. And we do recommend to wait.
There is one question that I'm going to ask now, but there's one. Eliza, I see your question. We have a whole talk about statute of limitations and the look back, so we're going to pin that and I'm going to leave it up. But the question I think that does need to be discussed now, and it's a doozy of one, but it'll lead to good discussion. Could you also discuss the intersection of the criminal case's impact on a civil divorce case, a non-tort case? A criminal defense attorney may try to get admissions in the civil divorce matter if the cases are going on at the same time. How would you suggest managing these issues?
Simple. Stay the case if you can until that criminal case.
The divorce case or the criminal?
Stay whatever you can, but chances are you're going to have to stay the divorce case. So really any case, and I've had that happen before where they've tried to you have a criminal case pending and then they use that civil process to gain information that they wouldn't otherwise be entitled to. So just voluntarily stay it until that criminal case is over.
Mm-hmm. Okay, so hopefully that answered. Again, none of us are family law experts, so I appreciate Jeff taking that one for the team. None of us are family law folks, but general wisdom and advice is stay the case if you can. Who wants to talk about intentional torts and get into torts? Jeff, go.
I'm always game. Sure, why not? I just have to see. Sorry, switching around here. I need to see your chart there. Okay, so when we talk about torts, it's an Old English term for wrongs, and in the civil justice process, you're bringing a lawsuit to make up theoretically for the wrongs that happened to you. Well, all torts get broken down two ways, into what we call intentional torts and negligent torts or non-intentional torts. So the intentional tort, what has to be proven is that there was a certain act that was done and that that act was intended by the perpetrator. And the act was intended and resulted in causing harm. So there's a lot of stuff packed into those few words, but that's the intentional side of things. I know we're probably going to talk about negligence in a second, but I'm going to talk about it now, if I may. And
We'll
so
just skip over.
by comparison, your negligent torts, you maybe don't have to prove that that perpetrator was acting intentionally. And so it's more about the elements of, was there a duty owed to that victim? Was the duty breached, and did that cause harm or damages? And this becomes really important in the civil context of representing victims, because, and one of the first things I do, I'm sure Guy, you do, and Brian, is sitting down and talking to the victim about, look, you know, we're not putting anybody behind bars in this civil case. We're here to get civil justice, and civil justice in America means money awarded to make up for the harms. So we really have to pay close attention to these negligence torts, negligence and other negligent related type claims, statutory claims, things like that. Because at the end of the day, if we're there with the goal to get money for our clients, we need to make sure that there, and I'm sure we'll talk about this later, but insurance coverage in place. So generally speaking, not generally, always, insurance is not going to cover those intentional torts, assault and battery, a sexual assault, or any type of intentional tort, but the insurance will cover negligence. So it's important, and it's not an either or choice where we say we're only going to bring intentional claims or negligence claims. We typically bring all claims because we're trying to get to the outcome that's going to help our client put their lives back together.
And just to jump in on there, people might be thinking, well, hang on. If you're representing someone who was raped, sexually assaulted, you know, what's the negligence in that, right? Like, how are you bringing claims if you're not bringing intentional? So when we're talking about institutional, just so everyone understands, and bringing these cases on behalf of survivors, you know, let the criminal prosecution, and I'll pick on the Catholics because I was a Catholic altar boy my whole life, right? Like, but so let the prosecution go after the individual priest. What cases like Jeff and I do, and Brian, like, we will sue the archdiocese or a diocese if they don't have an archdiocese. And what we say is, you negligently supervised, you negligently trained, you negligently credentialed this individual who was the priest that you put in a position of power over children when you should have known better because of the person's record or whatever it would be. And those type of claims are what triggers insurance. So that the churches, schools, things along those lines can purchase insurance for a supervisor, a pastor, a bishop's, right? Their behavior in doing something negligently. Like, you shouldn't put a priest in a position over children who you know has a history of abuse, right? I mean, it's just that simple.
And so we skipped way ahead very quickly, but that is a good thing. So just to go back, when we have those intentional torts, those are called, and I'm sorry I'm skipping around, I'm trying to keep up with Jeff and Guy and make sure I put a bow on everything. Those intentional torts, when it's the assault, when it's the sexual assault, we would call those first party defendants. And these are all the folks that you could, in theory, try to sue. But as Jeff and Guy said, they're not always the best option. And that's because sometimes there's a lack of insurance, there's a lack of money, but also there's an emotional toll of, we've worked with several victims in this space, and leaving the swear words out because we are on a very public conversation, oftentimes the victims say, look, I was screwed over once by the person who hurt me. The bigger time I was screwed over was by the organization that was supposed to keep me safe. So it's not just that we're saying you were negligent in doing these things, it's you were given a duty. And not only were you responsible to keep these children safe where you failed, but second of all, oftentimes you tried to hide the fact to protect your money that you messed up. So We often do try to go after those institutions, and we're going to talk about a lot of the reasons for victims. But first, and very importantly, we want to get to Eliza's question, which is how do statutes of limitations work and damages? Who wants to take statute of limitations for civil cases in Jersey and do the explanation?
Jeff, you're the smartest person in this panel, so yeah, you go ahead.
You're too kind, Guy. All right. So the important thing to know is they vary widely. Statutes of limitations are a time limit for bringing a civil case, and they vary very widely based upon essentially the theory that's being pursued and different circumstances. So whatever the criminal statute of limitations in has nothing to do or almost nothing to do with the civil statute of limitations. That's important. One thing that's unique, and then I'll talk about some of the window and other statute of limitations, but one thing that's very unique to New Jersey is for murder, for any intentional killing of a person, there is no statute of limitations. So I've looked at cases that date back decades and decades for that reason. That is only against the perpetrator, though, that first party defendant. So let's talk about, and you see a lot in the news about what's called window legislation. I'll try and summarize this, although I've been working at it for about 20 years, trying to get the law changed in New Jersey. So in New Jersey, it's universally recognized in the social science that survivors of child sexual abuse don't come forward till much later in life for a bunch of reasons. The most important being they don't think they're going to be believed, and therefore it's a fear of telling. I believe that according to Child USA, the average age of an adult who was a victim of child sexual abuse, the average age that they come forward is 52 and a half years old. So used to be in New Jersey that you had until age 20. If you were a victim of child sexual abuse under 18, you only had until your 20th birthday. That's changed, however. And it's changed in a positive way in New Jersey in three different ways. Number one, they had opened up what's called a window or a limited time period that if you bring your lawsuit by such and such a date, then it's going to be considered timely and within the statute of limitations. That window has closed in 2021. So in keeping up with the social science as when victims are able to come forward, they've also extended the statute of limitations to age 55 of the victim. So as long as you have not reached your 55th birthday, you can file a lawsuit for child sexual abuse. And that's against both perpetrators and what we call institutional defendants like schools, hospitals, et cetera. But there's still another way in New Jersey, and that is the courts will allow 7 years from the date that you reasonably discovered that your injury, that A, you had an injury, and B, that injury was caused by child sexual abuse. So if I'm a victim, if I'm a survivor of child sexual abuse, I knew that I've always been abused. And I also known that I've always had some sort of diagnosis or mental health issue related to this. But I've never quite put together the two, that one led to or caused the other. Well, if I'm realizing that today in June of 2025, then I'm going to have another 7 years to bring that lawsuit. And then as the outline says, each cause of action has different timeframes. I mean, it's short for defamation, 1 year. It's generally a 2-year statute of limitations, but luckily the legislature in 2019 recognized the need for change after a lot of work by National Center for Victims of Crime and other organizations, and getting that law changed to allow for those windows.
And then I do have one question. That's my question. We say reasonably should have discovered. Is there any advice on what reasonably should have discovered means?
Well, like everything in the law, it's in the eye of the beholder, and in this case, the beholder is your judge. And I've seen judges do different, have different takes on this. But as a sort of ground starting point is if you've never either been diagnosed with a condition, or maybe you have been diagnosed, but no professional has ever told you that it's caused by your incidents of sexual abuse, then that's what starts the clock running once you've been told by a professional. And I would defy any defendant to come in and say that somebody should have realized that beforehand.
That's right. The just as a put a fine point on it, we want all victim survivors to get therapy, but when you're filing, and I've filed so many cases under discovery rules, unfortunately, if they had treated and they discussed the sexual abuse or assault, to Jeff's point, that is really when that clock is started. I mean, it's. I mean, I hate thinking in terms of impossibilities. I always try, I know Jeff does as well, to creative ways around it. But if they treat it more than 7 years ago, it is almost, if not actually, impossible to get around the discovery rule.
And just to tie all of these questions back into the earlier question of timing, when you are also working with a criminal case, because these are all going to come about because of crimes, how are you advising your clients as to how to work with this statute versus the criminal statute, and what's the timing on cases that you recommend?
Guy?
Yeah, I mean, so if it's a whenever you're dealing with an adult who's been sexually abused, and this is some states are better than others. Jersey's okay, it's not great. I mean, but
I think it's great.
okay for adults. But
Yeah, it can work. Yeah, it's
okay,
workable. Yeah.
it's workable. But if you have an adult who's not reporting in close to real time, you can have a problem with statute of limitations. Now, when you're talking about children, you usually have, not in every state, but Jersey for one, for example, you have a pretty good amount of time, depending, of course, when the victim survivor comes forward. In other words, generally speaking, statute of limitations for civil cases when it's a child case really isn't a major concern for me when I'm asking the client and advising the client on waiting for the criminal process to play out. We don't always have that luxury in adult cases, depending upon when the adult came forward, right? So, and most of the survivors who have come forward and have sought criminal justice and also want civil justice, I mean, I probably can count on one hand pushback that I've gotten from a victim survivor who doesn't heed that advice, meaning let the criminal process play out and then we'll go and file civil justice. Because to Jeff's point earlier, rarely is money discussed by victim survivors. I mean, obviously they know it's a remedy because we talk about that, but it's just so far from their mind that instead what they want is just accountability and holding the perpetrator, obviously, for punitive measures and removing them from society if that's appropriate. That they're willing to go the distance, albeit knowing that it's not an easy road they're going to be traveling, but it's one that they want to do because they want their voice back, because they want control, because they want that accountability.
And I think Guy brings up an excellent point. We do tend to get buried deep in the child sex abuse cases, and so just to point out, because we do recognize this, that there are adult cases, and so we do have these other statutes listed. They are New Jersey statutes. We have libel, slander, defamation listed. That is actually for victims who are accused of libel, slander, or defamation. That is a 1-year statute. A lot of times you do see perpetrators hitting victims or trying to intimidate victims away from these cases, so they will file those. It's a 1-year statute. There are anti-slap suits that we're not going to talk about much today because they're so nuanced, but that is important to know. Fraud is a big one. There's a 6-year statute in Jersey, which is frankly one of the longest I've seen. Professional malpractice comes in, and this is an interesting one. You can sue for professional malpractice in crime victims cases, specifically physicians, if they've missed something. So the best example I have was we did have a young woman who came to us who had brought her daughter to a physician. Her daughter was 13 years old. Her periods were irregular, and the mother told the physician there was a language barrier. The physician did not do a pregnancy test. She brought her child again. 5 months later, said the periods were still irregular, did not do a pregnancy test. They did not know this child was pregnant until she gave birth. It turns out she had been being raped by her stepfather the entire time. The mother sued the physician for medical malpractice, which is not rare. And so it is important to know that, again, Jersey has some of the best statutes I've seen. Professional malpractice, 6 years is huge. And then personal injury, which is what most adult sexual assault cases fall under. Unfortunately, we consider them personal injury. That's usually about 2 years.
Mhm. And real quick, Renee, there was a question about if I could share some case law that speaks to the discovery of the harm. The quintessential case on that is the Voytac case, Voytac. Now that's a case that was maybe about 10 years or so ago, and it's since been sort of written into the law in the Child Victims Act, which is that body of law that opened up and extended the statute of limitations. So Voytac.
So I think we have fully covered statute of limitations. We always do, but this is always one of the most confusing parts of civil law, especially with how it intermingles. So I'm keeping an eye on the Q&A. We're not going to talk about statutes or timing anymore. So this is your chance to ask questions or hold them for the end, but we're happy to answer those, but we're going to move on from this. But I know this is the most confusing part of the law. Damages are the other big part that we've talked about that are different in civil cases. There are two types of damages. There's compensatory, and then that's broken down into economic and non-economic, and there's punitive. Compensatory are the bigger ones. Guy, do you want to explain those and any caps there are in Jersey?
Sure. So compensatory damages are for your individual harms, right? Or the losses that derive therefrom, right? So, it's making the person whole. Obviously, money doesn't really make someone whole, but that's the best that we know how to do, right? To can't take back what happened. You can't give back someone their childhood. And so the idea is that money is to make the individual whole. And so what does that look like? Well, it's pain and suffering. It's emotional harms, psychological damages. If there's, physical harms, scarring, bruising, burning, things along those lines, and there's medical treatment that needs to go with that. So the non-economic is most of those things I just said. It's your psychological, it's your pain and suffering. It's what you are dealing with on the inside, suffering oftentimes in silence. And then your economic damages, if you have them, are your medical bills, potential lost wages, anything that's actually calculable, right? Can you put an actual number to it because there's a bill, for example, or you were charged something. And so you can seek all of that in your case against oftentimes the institution that allowed it to happen. And so compensatory damages is all about making the victim survivor whole again. What is the amount of money that will do that? It is the shortest way to say it.
And I want to ask all of you, because that non-economic is tough in these cases. A lot of times, we all learn in law school about the scar. How big is your scar and how seeable is it? That shows cases. These are cases a lot of times with victims of crime that you can't see the scar. So how do you go about proving those non-economic damages?
Yeah, oftentimes, at least the way that I sort of like to think about it, I know, there's a lot of others, and, and Jeff obviously will give his take on it. I view it, and this is not the law, and this is not how any juror will ever hear it, but, in our cases, we're getting punitive damages before we even talk about punitive damages. In other words, how do I prove up non-economic? Yes, you could have the victim survivor talk, and as they will, all about the ways they suffered. But before you even get to that, generally speaking, it is the conduct of the defendants, meaning the institutional defendants, that really at the end of the day drives that number. Meaning the worse that it is, so, take the Sandusky cases, take the Catholic Church cases. We all know now that for hundreds of years, literally hundreds of years, the Catholics have been hiding this in their secret archives, and their conduct was atrocious for well over 100 years, if not longer than that, at least as documented. Meaning, before you even talk about your victim survivor, the jurors are so incensed that that is going to drive the value of those compensatory damages. When you couple it, of course, you still need to couple it with what did your client go through, both in the moment and then ultimately as they progress through life, right? What are all the harms? And that's why you bring in psychiatrists, psychologists, their doctors, their treaters, our experts, things along those lines to tell the whole story.
And it's little things. We had a case where a woman couldn't sleep in her bed at night. She had to sleep on the couch every night because she was afraid somebody was going to break in. And what is the value of being able to sleep in your bed?
Yeah, and you put it to jurors like that. You know, I had a woman who was sexually assaulted at a massage institution in New Jersey, and the perpetrator focused very heavily his assault on her breast. And at the time, she was pregnant. And when she gave birth, and she knew, I mean, PhD, she was a very bright woman. You know, she knew, and it drove her crazy. It made her sick to her stomach. But when she tried to breastfeed her child, it made her sick. Like she could not do it. And it, like, she hated herself for that, right? You know, worked through it, knew that it's obviously not her fault. The point in sharing all that is that that's a, you know, any mother, right? Like if your choice was to breastfeed and that has been taken from you, like it's kind of perverse. We're trying to quantify the unquantifiable, but that's what you said. What is that worth? You have one, you can't go back and do it later in time, right? I mean, like this is your chance if you were going to breastfeed your child, and this was taken from her. And so, you know, when you put it to jurors like that, most, not all, but most will do the right thing when it comes to valuing that appropriately.
We do have a question in the chat. You know, let's get to punitive, and then we're going to ask that at the end. We're going to ask that question at the end. Punitive damages. Jeff, do you want to explain them? These are some of my favorites.
Okay, so what Guy has talked about is compensatory and how that might break down, and that's about making the victim theoretically whole, and you know what was lost and how do you make up for it. Punitive, and you know this is frankly the way I explain it to juries, is this is about what the defendant did or failed to do, and they're entitled, if they believe that the evidence supports it, to punish and deter that conduct. Deter not only that defendant, but let's say we're suing a hospital, and it's not just that hospital, but all hospitals. They need to know that if you allow a perpetrator to work amongst your ranks, then you know, not only you're going to be hit for the compensatory damages, but you're going to be punished on top of that. So that means an additional dollar award above that. And what amount punishes that? So look, Renee Williams, you know, she's very accomplished. I saw her smoking. It's a bad habit, but I saw her smoking and lighting up $100 bill to light up that cigarette. And you know, money means nothing to her. So it's going to take a lot more money to punish her. I don't mean to make you the butt of the joke there, but and so it varies based upon the defendant. If you're suing Walmart for, say, you know, for example, they're one of the largest corporations in the world, and it's going to take a lot more money to do that. In New Jersey, and I'm just jumping to the outline here, which I never do, there is a cap of 5 times or $350,000, which doesn't sound to be that much because the compensatory damages could be in the millions, yet you're capped on the punitive damages under the statute to either 5 times the compensatory or 350. It's actually whichever is the lower of those two. But if you contact somebody like Guy who knows what he's doing, he's going to bring certain claims that allow you to get around those caps. So there's a law called the law against discrimination that applies a lot in sexual assault cases. And there is no cap on punitive damages there. And there's a law in New Jersey called the New Jersey Child Sexual Abuse Act. There's no cap on punitive damages there either. So it's important to reach somebody that knows what they're doing when it comes to punitive damages.
And I think I can give a good example of punitives that's not me smoking $100 bill, which I would never do because I don't smoke.
I'm kidding. She doesn't smoke, and she doesn't make millions of dollars even.
Sure don't. but there was a case, and it was actually in Pennsylvania, not New Jersey. And this is one of my favorite stories to tell because I think it's so interesting and it so phenomenally highlights what punitive damages are and what they can do. There was a young man in a juvenile facility, incarcerated in a juvenile facility, and the facility had a camera facing his door, and the camera was on. The security camera worked, and they noticed a much older um, juvenile coming in constantly and closing the door, and this was frequent. And he was sexually abusing the other young man. Um, the attorneys who worked it, and it was not Jeff or Guy or Brian, put the young man, the victim, on the stand, and he essentially tried to make a case that he was not a victim. And so the compensatory damages came back to him as like 5,000 because the jury found that he was not harmed. But during the trial, there was so much testimony about that video camera and what could have been known and how it could have been stopped if the facility would have just reviewed it. And that was all they needed. So I want to say the punitive damages came back against the facility is like 500,000, whereas they gave the young man like 5,000 in compensatory damages. So punitives really are a way to say, no, you've done so bad. Like you could have stopped this. So it has nothing to do with what the victim suffered. Before we move on from damages, we'll call this question out now. And I honestly don't know the answer. I'm hoping we have an international law expert on. Are there countries who have similar civil justice systems other than the US, UK, where civil cases have this type of action?
I am not an international guy, but don't we have members from Canada as well?
We have members in the UK as
Yeah.
well, but
So
we're looking at non-Westernized.
yeah. So I'm in terms of just overall tort systems, there's tort systems available in a lot of different countries. And it's really going to vary depending on what type of money damages are available. I've pursued cases in Mexico, for example, and it's very, very limited. It's sort of a factor of an average wage in that given state in Mexico. But maybe that's my next frontier is to go internationally. But sorry, I don't have more of an answer.
Brian, Guy, I don't know either.
Never, not the specific UK. This is anecdotal at best. There are UK plaintiffs' attorneys who have I don't know how they have a case in Pennsylvania, but they do. And I've been advising them and will probably be their local counsel, so to speak. In any event, they were blown away by what is available in terms of financial remedy. So it just seems like we have a better system, but I don't know that for true. And that could just be me, my bias towards the US, but it just in my talks, and that's the best I can do is very anecdotal.
And I will chime in if there is a case, so this gets very complicated, but if there is a victimization case that occurs internationally, we encourage individuals to try to find a hook that brings it to the US or the UK. And so what I'm thinking of is we did get a case where a young woman was injured at the embassy, the US embassy, by someone. And so we tried to use that as the hook to bring it. So we do usually encourage people to try to bring it back in. We do have
100%.
lawyers in the UK and in Canada as well. What was that?
Yeah, I 100%. I just filed my firm and Mike Haggard's firm 13 cases down in Florida for a Jamaican boarding school. And the theory of liability is that these RAD, reactive attachment disorder programs, and the transportation companies and the educational consultants all knew what was going on and convinced these parents to send their children over there as the cure. And so, we'll see if the federal courts agree with us, but at least we're taking a shot at it in Florida.
There is an entire class called Conflicts of Law that is the most difficult class you could take. And I think we're none of us are experts in it. Again, I don't know Brian as well. Maybe he is, but conflicts is very difficult and we're creeping close to that. One other question. When you bring an LAD claim in conjunction with sexual assault, student on student, and in conjunction with the school's failure to act to the fallout, including bullying, what statute of limitations applies?
That's a hotly, I'll take that. That's, well, actually, Brian, maybe, Brian, why don't you speak first? Do we have
Sure.
one?
Yeah, that's an issue that Jeff and I are frequently litigating in our cases. We always take the position. Well, let me back up. So the LAD statute explicitly cites to the provision of the New Jersey Code that sets forth a 2-year statute of limitations for personal injury claims. So LAD itself says that it's using the statute of limitations that applies to personal injury actions. So one of the things that we've been litigating a lot is we recently talked about how the statute of limitations has been amended for the victims of child victims of abuse. And a lot of the defense is taking the position that that provision that amends the statute of limitations does not apply to LAD. Jeff and I have been taking the position that no, these amendments to the statute of limitations does apply to LAD. So far, we've been successful. I'm not aware of a lot of case law coming from the appellate courts that have definitively answered that question, but I think that from an intuitive, logical perspective, the argument makes sense. The courts, when they amended the statute of limitations to make it easier for victims of abuse to find civil justice, they made that amendment in recognition that these victims should be able to seek justice for any sort of civil wrong that they suffered on account of child abuse. And so far the courts have been agreeing with our interpretation.
Hope that answers the question.
In civil cases, if the victim dies and the death is unrelated to the case, while the case is in litigation, does the case come to a close?
That's a big it depends, right? So I've had cases like this where if the individual had been deposed or there is sufficient evidence despite the victim not having been deposed to continue with the case, and you can do it then sort of in care of, you find next of kin. So maybe it's a parent, maybe it's a sibling, maybe it's a spouse, a child. So it's not necessarily, I know this is like a lawyerly answer, but it's the truth. I mean, it doesn't necessarily end the case, but it can. I had a priest abuse case in New York because they opened the window where, 2 weeks after we filed the lawsuit, sadly, unrelated, he was in his late 70s. He died of natural causes. And there wasn't a ton of records. And no one could really substantiate, not that he wasn't telling the truth. I believed him wholeheartedly, but I wasn't going to be able to pursue it because I didn't have any evidence that would allow me to do that. So I don't think it's certainly not a death knell by any stretch, but it doesn't, it can be challenging. Jeff, I don't know if you share the same.
Yeah, I've had similar experiences to Guy, but essentially, as long as there's somebody who can stand in the shoes of the deceased person as an either administrator or executor of the estate, the case can still be pursued. And then the second part of the filtering process, like Guy said, is, well, do we have the proof, though, to prove the case? And that's a process that we would have to endeavor. The interesting thing that comes up is, if the defendant dies during the case, what happens then? Well, same answer, more or less. The defendant, if they left a will, or if somebody is serving as a representative of the estate, then you just substitute in the representative for the defendant themselves. If the defendant or their family doesn't do anything to get a representative named, then maybe we have to do it. And I've done that too, where we go and petition the court and get somebody appointed, right? So
Thank you for those.
interesting question.
You do have a chat. Rita will be reaching out to you because she does have some follow-up questions. So Rita, we're going to make sure that their information is available at the end. So we've walked everyone through the really high level of the civil justice system, right? Who do you sue? Why do you sue? What money can you receive? What actually happens through that system? We want to talk about some of the reasons that people get very upset when they send me a case and I say, I can't refer this to an attorney. A lot of times that has nothing to do with whether it's a good case, whether I believe that victim or not, whether the thing that happened to them was or wasn't horrible. They're just really tough decisions that attorneys have to make and that we have to make before sending on a case. So I first want to talk about some of the advantages, which I think you've all heard before, and we've been going over these certainly. I went too far. And I don't know, Guy, Brian, Jeff, do you want to just call out any of your favorites on these for some reasons that victims come forward that is not have anything to do with money?
I'll call out. The incentives for crime prevention and promoting change is huge.
Mhm.
I hate to go back to it, but when Jerry Sandusky was arrested on November 5th of 2011, the entire world of child safety can be separated into before Sandusky and after Sandusky. And because the civil cases were pursued and those criminal cases were pursued, you saw a mass change in the laws, not perfect, across the country and probably even across the world in terms of prevention and safety for children. So that, and it's also as simple as, you know, when you check into a hotel these days, you get a card key. You don't get a key with the number, room number 302 printed on it. That's because of civil lawsuits. And that's a big part of why these cases are pursued.
So I can't say it better than Jeff did as to that one. Sense of control. I'll jump in with that one. So many clients, no one likes to be deposed, but when they get to tell their story almost uninterrupted and walk through and make decisions with their lawyer that they're actually making decisions and fighting that with someone who they know is really on their side and who is really there every step of the way, it's incredibly empowering, and the control that so many victim survivors feel after civil justice, and sort of what you hear at the end of a case is what always motivates me to continue doing what we're all doing here.
Brian, you want to shout one out? Your favorite reason for bringing a suit?
No, thank you.
Well, I'll say mine are
Just
kind
because
of,
it's the right thing to do.
yeah, there you go. Well, mine are intermingled, and it's personal justice with that sense of control. And I think for me, some of the examples are, the older example is the O.J. Simpson case. Victims always have a right to try to hold an offender accountable, and a lot of people will yell, "What about double jeopardy?" Well, keep in mind, O.J. Simpson was held liable for Nicole's death. So did a jury say after weighing all of that evidence that he didn't kill her? Yes, they did. But did they find that he was responsible for it because it was a different burden? Yes, they did. And I think a newer example is with the Diddy case. And I mentioned this earlier, but I think it's important to repeat. Especially in sexual assault cases, child sexual abuse cases, and domestic violence cases, there's a criticism of people who find civil attorneys first and who file lawsuits. But that criticism is misplaced. That criticism needs to be on law enforcement. We know the prosecution of all of those cases is so low, that you almost put the victims in more danger by bringing them by bringing charges. And so by being able to find an attorney and sometimes frankly hitting people where it hurts, um, that helps. And I'm seeing the question about if there will be a mention of the Menendez brothers case. Right now, no. The Menendez brothers, I don't believe, unless I've missed something, have not filed a civil suit, nor has anybody filed a civil suit against them. So
Not
they
that
they
I'm
don't,
aware of. Yeah.
yeah, they don't really fit in right here. I have all sorts of opinions on what's happening there and on the documentary and on Ryan Murphy himself, who made the documentary, but we don't have 2 hours for me to get on that soapbox. But I'm so happy to share them later. Yes, they could sue for damages against the state if they choose to do that. I don't know if anybody wants to talk about what approach they would have if they wanted to sue the state. Um, Yeah, I think we're all not going to touch that one. But I am willing to talk over a beer about it if somebody wants to take me for a beer. Moving on, there are some disadvantages to the justice system, and these are the reasons that attorneys often will not take these cases, and they're super important for you all as victim advocates to know about so that you can fully prep your victims. And we're down to 10 minutes because we've been talking way too much, but if you hear nothing else, some of this is super important. So, some of the disadvantages. Guy, do you want to go as Jeff's having a coughing attack?
Sure. So, I'll the part about it being expensive and so many times that, and it breaks my heart, it really does, when we have to tell a victim survivor we can't bring their case, and despite doing it trauma informed and walking them through it, I know what they hear, and it's, you don't believe me. And that is, couldn't be further from the truth. If there isn't a viable path to a recovery for a client, like a truly viable path, meaning, is there someone who could satisfy what a verdict would be at the end of a trial, or at least a portion of the verdict? And if the answer is no, then you're just putting a victim survivor through the civil process for the sake of going through the civil process, because they can't actually achieve anything if there's not a potential recovery to hold someone accountable for out of. And so oftentimes it comes down to that, which is why you don't see many cases exclusively against an individual perpetrator. Not saying it won't happen and can't happen, i.e. P. Diddy, right? But that's the very rare circumstance where you have a billionaire or even multimillionaire who's doing these type of things, right? Of course, we think that's all that happens because it's nonstop in the media, Weinstein, Epstein, P. Diddy, right? But the reality for most individuals is that is not who their assailant is. And so can become very challenging to bring a case if there's not a viable path.
Do you want to talk about re-victimization and the difference in the civil process versus the criminal process, especially with depositions and putting themselves at issue, and kind of what that process is and how you prep victims for that?
Sure. So I think re-victimization is always a problem. I'm sure folks are familiar with the most common diagnosis associated with a crime and its impact on the victim is post-traumatic stress disorder, which by definition is somebody experiencing a trauma, and then any reminders of that trauma cause symptoms to either come out or get worsened. So the strategy that I've employed, and I know Guy as well has, is number one, and this just sort of hit me in the last few years, is recognizing that you sort of have this cycle. So if I'm representing somebody, I'm nothing but a reminder of that crime. So almost a discussion of it and recognition of it helps smooth the process. But really, it's about working with the survivor, your client, and also with either their trusted family member or their counselor or therapist in preparing them for these various steps. Now, there's a bunch of things that can be done to help in the process, such as using a pseudonym like a Jane Doe or John Doe for the person. And sometimes, under some circumstances, doing a deposition with closed circuit TV, or we found out sort of the hard way, we didn't have a choice, that doing Zoom. My client, I was afraid that Zoom was going to be a problem for clients testifying who were survivors of violent crimes, but they actually found it easier because they're sitting in their own house. And as you mentioned on the slide there, yes, mental health records, medical records can be accessed by the defense attorneys. This just underscores the need to sort of stage the timing of bringing a civil case, and do so after that criminal case is done. But it's just really being prepared and working with your attorney and your counselor to be prepared.
And importantly, leading into our next slide, your role as advisors and as advocates and victim advocates, Look for good attorneys. Look for attorneys that understand those things and can walk you through. I will be honest, I just drove through New Jersey this weekend and I saw so many billboards. And when you start to see cases come up, like the Catholic Church cases, like the Diddy cases, you have attorneys that have no business being in this space, getting into this space, and they're not seeking help because they think they can treat this like a car accident claim. So one of the biggest things you could do as advocates is help vet attorneys. Couple of things you really need to be careful about. You do have an absolute privilege when assisting victims. However, disclosure is still required if the defendant's constitutional rights are implicated. What that means is don't give victims legal advice or guarantees. Don't do that anyway, but be very conscious of what you're writing in your notes, especially when you're discussing things like memory and when they remembered sexual assault or sexual abuse, and things like your discussions with them about filing a civil case. So just be very aware. Some of the best ways to find trauma informed, victim centered attorneys. Make sure they have, again, an interest and experience, that they understand victims' needs. There are tiny little strategies that you don't think about that are crucial in filing a civil suit that only attorneys that have been doing this a long time will know. My favorite example, because I publicly called this man out, the attorney that is taking all of the Diddy cases dropped the ball epically because he did not know how to file an anonymity statute. And so the court ruled that the victims this attorney was representing had to be named. There are simple tricks to get around that. And he messed up epically. And so those victims, and I can't remember because I didn't look if they proceeded with their case or not, but that's a huge mistake. And there are little things like that that you need to have a knowledgeable attorney. And you also want to make sure the attorney is speaking to the clients in the correct way. There are ways to ask questions that don't sound accusing. All of our attorneys are trained on PTSD, are trained on how trauma works with the brain, to understand that a victim's answers might come differently and they might not be what we expect, but that doesn't mean their case isn't real. So make sure that you are helping them find cases like that. And I rushed through those, but again, we're going to send you all of these because we have 3 minutes left and we do have 2 questions and one's going to take a really long time, and I know this. This one's going to be short. I have a survivor that asks if they can hire an attorney who gets paid after their civil case from the compensation they receive in the civil case. Is that a thing?
Yes, it's the only way at the end of the day to truly represent a survivor, because large part, a survivor would never be able to pay, for the most part, what it would cost to both pay for an attorney and pay the cost, the actual hard cost of litigation, which can be at times well over $100,000, if not way more.
And will that cover all of the costs and the court costs and the deposition
100%.
fees and all the
And if
things?
there's a loss, if the case isn't successful, the client owes me, and I know Jeff works the same way, not one single penny out of their own pocket.
That's right. And that cost, by the way, is usually a contingency fee of no more than 1/3 after deduction of expenses. So if we recover $100, $100, 100,000, 100 million, those expenses would come off the top, and then 1/3 of that is what gets paid to us. And if we don't produce the result, we don't get paid.
Mhm.
And this one's going to take a little longer, but I like it. What if the assault happens on an international cruise and it's on international waters? How can this be pursued in court? What court? Assuming both the victim and the perpetrator reside in Jersey, or does it matter where they reside?
So I've been down that road, and there's a couple considerations. Typically, if you can get what's called, I don't want to turn this into a law school class, but if you can
Yeah,
get
because you only have a
jurisdiction,
minute.
if you can get jurisdiction over that person or that company in New Jersey, then you can sue them in New Jersey. That's the short answer. And sometimes, especially on cruises, they force you to litigate cases in Miami, Florida.
Mhm.
And we have
Maritime law.
members of the Bar Association in Miami.
We do.
How's that for a short answer?
You did brilliantly. We still have 30 seconds and no more questions. So with that, I would like to thank everybody for joining us today. If you look at the chat, Krista has put the link to the survey. Once you fill out that survey, we will be sending you a certificate of attendance. And also, yes, these slides will be available to you via email by the end of the week. We will also absolutely have this up on our YouTube if you would like to watch this. And again, in that email, we will have the email addresses, woo, for Jeff, Brian, and Guy if you would like to reach out and contact them. We're right at 1:30. We appreciate you all for joining us. Have a great rest of your week.
Thank you all.
Thank you all.